Okay, thank you, counsel. Mr. Davis, anything else?
No, sir. Doesn't believe anybody raised their hand.
All right. Again, we just wanted to make sure that there was no relationship between any juror and those three potential witnesses, and the court's comforted by addressing that issue this morning that there's no inappropriate relationship, and it would not cause any of these jurors not to be able to participate as a juror in our case today. At this time, what I'm going to do is go ahead and begin with our preliminary instructions after swearing the jury in. Again, it's been a few days since we've seen each other on our jury. At this time, I'm going to go ahead and have the state reintroduce themselves. Sir, if you'll stand up, please.
Williams, representing the state of Florida in this case.
Thank you, Mr. Williams. And Mr. Davis, if you'll announce yourself and your client, please.
Good morning, everyone. My name is Ryan Davis, and I'm here representing Mr. Zachary Wester.
Mr. Wester, if you'll stand up too. Thank you, sir. Appreciate it, Mr. Wester. You'll notice we've got various screens located. I've got a screen in front of me. If there's any issue hearing or seeing, please let me know. In fact, the best way to do that is if you can't hear something, if you'll raise your hand, I'm constantly looking out the audience. That will tell me that you're having an issue hearing, and we'll do something different to make sure that you can hear what's being said today. At this time, is there any reason from the state or the defense that we should not go ahead and swear in our 9 jurors?
No, Judge.
No, Your Honor.
All right. If all men and gentlemen of the jury, you have been selected and sworn as the jury to try the case of State of Florida versus Zachary Wester. This is a criminal case. Zachary Wester is charged with racketeering, official misconduct, perjury, fabricating evidence, possession of a controlled substance, possession of drug paraphernalia, and false imprisonment. The definitions of these crimes will be explained to you later in this proceeding. The state's charging document, which is called an information, is not evidence and is not to be considered by you as any proof of guilt. It is my responsibility to explain the law to you in this case. It is your solemn responsibility to determine if the state proved its accusations beyond a reasonable doubt against Zachary Wester in accordance with the law that I provide to you. Thus, the province of the jury and the province of the court are well defined, and they do not overlap. This is one of the fundamental principles of our system of justice. Before proceeding further, it will be helpful if you understand how a trial is conducted. At the beginning of trial, the attorneys will have an opportunity, if they wish, to make what we call an opening statement. The opening statement gives the attorneys a chance to tell you what evidence they believe will be presented during the trial. What the lawyers say is not evidence, and you are not to consider it as such. Following the opening statements, witnesses will be called to testify under oath. They will be examined and cross-examined by the attorneys. Documents and other exhibits also may be produced as evidence. After the evidence has been presented, the court will instruct you on the law applicable in this case. The attorneys will then have the opportunity to make their closing arguments. Following the closing arguments by the attorneys, the court will conclude with the final instructions. After the instructions, you will retire to consider your verdict. You should not form any definite or fixed opinion on the merits of the case until you have heard all of the evidence, the argument of the lawyers, and the instructions on the law that I will give you. Until that time, you should not discuss the case amongst yourselves. Your verdict must be based solely on the evidence or lack of evidence and the law that I will give you. I now instruct you not to communicate with anyone, including your fellow jurors, about this case. No communication includes no emailing, text messaging, tweeting, blogging, or any other form of communication. You cannot do any research about the case or look up information about the case. If you become aware of any violation of these rules, please notify a bailiff and I will address it. During the course of the trial, the court will take recesses, and you will be permitted to go separate and go about your personal affairs. During these recesses, you must not discuss the case with anyone, nor permit anyone to say anything to you or in your presence about the case. If anyone attempts to say anything to you or in your presence about the case, tell him or her you are on the jury trying the case and ask them to stop. If they persist, leave him or her once immediately, report the matter to the bailiff, and I will deal with it. All cell phones, computers, tablets, or other devices must be turned off while you are in the courtroom. Turned off means that the phone or device is actually off and not in silent or vibrating mode. You may use the devices during your recesses, but even then you may not use your cell phone or device to find out any information about the case or communicate with anyone about the case or the people or places involved in the case. Please do not take photographs, video recordings, or audio recordings of the proceedings or of your fellow jurors. After each recess, we will double check to make sure that our cell phones and devices are turned off. At the end of the case, while you are deliberating, you will not be able to communicate with anyone outside the jury room. We will talk about that as we get to the end of this trial. The case must be tried by you only on the evidence presented during the trial, in your presence and in the presence of the defendant, the attorneys, and the judge. Jurors must not conduct any investigation on your own. This includes reading newspapers, watching television, or using a computer, cell phone, the internet, any electronic device, or any other means at all to get information related to this case or the people and places involved. This applies whether you are here at the courthouse, at home, at lunch, or anywhere else. You must not visit places mentioned in the trial or use the internet to look up maps or pictures to see any place discussed during the trial. Jurors must not have discussions with friends or family members about the case or the people and places involved, so do not even let the closest family members make comments to you or ask you questions about this trial. In this age of electronic communication, I want to stress again that just as you must not talk about this face-to-face, you must not talk about this case by using any electronic device. You cannot use phones, computers, or any device to communicate about this case. Do not send or accept messages related to this case or your jury service. Do not discuss this case or ask for advice by any means, including posting information on a website, chat room, or blog. Why do we have these rules? And we discussed this at length last Wednesday. These rules are imposed because you as jurors must decide this case without distraction and only on the evidence presented in this courtroom. If you investigate, research, or make inquiries on your own, I have no way to make sure that the information you obtain is proper for this case. The parties likewise have no opportunity to dispute or challenge the accuracy of what you find. This is contrary to our judicial system. Our system assures every party the right to ask questions about and to challenge the evidence being considered against it and to present argument with respect to that evidence. Any independent investigation by any juror would unfairly and improperly prevent the parties from having that opportunity that our judicial system promises. Any juror who violates these restrictions jeopardizes the fairness of these proceedings, and a mistrial could result that would require the entire trial process to start over. A mistrial is a tremendous expense and inconvenience to the parties, the court, and the taxpayers. If you violate these rules, you may be held in contempt of court, face sanctions, serving jail time, paying a fine, or both. The attorneys in this case are trained in the rules of evidence and trial procedure. It is their duty to make all objections that they feel are proper. When an objection is made, you should not speculate on the reason why it was made. Likewise, when an objection is sustained or upheld by me, you must not speculate on what might have occurred had the objection not been sustained, nor what a witness might have said had he or she been permitted to answer. During the trial, it may be necessary to confer with the attorneys out of your hearing to discuss matters that require consideration by me alone. It is impossible to predict when such a conference may be required or how long it will last. When such conferences occur, they will be conducted so as to consume as little of your time as necessary for a fair and orderly trial of the case. If you would like to take notes during the trial, you may do so. On the other hand, you are not required to take notes if you do not want to. That is left to you individually. You have been provided with a notepad and pen for your use if you wish to take notes. Any notes that you take will be for your personal use. However, you should not take them with you from the courtroom, and Mr. Gary, our bailiff in the back, will help us with that process. During recesses, Mr. Gary will take possession of your notes or will make sure they are secure and will return them to you whenever we reconvene. After you complete your deliberations at the end of this case, the bailiff will deliver your notes to me. I will personally destroy your notes. No one will ever read your notes. If you do take notes, do not get so involved in note-taking that you become distracted from the proceedings. Your notes should be used only as aids to your memory. Whether or not you take notes, you should rely on your memory of the evidence, and you should not be unduly influenced by the notes of other jurors. Notes are not entitled to any greater weight than each juror's memory of the evidence. The attorneys will now present what we call their opening statement. Please remember what the attorneys say is not evidence or your instruction on the law. However, do listen closely to their statements. They are intended to aid you in understanding what they believe the evidence will show in the case. Is the state ready to proceed?
Yes, Judge.
Counsel?
Okay, please support Mr. Davis, Mr. Wester. Good morning, everyone. As I said a moment ago before we got started, my name is Tom Williams, and I'm representing the people of the state of Florida in this case. The defendant in this case is Mr. Zachary Wester. He is a former sheriff's deputy from right here in Jackson County. And while he was a deputy with Jackson County, he carried a badge and he carried an ID card that you'll get to see as an item of evidence. That ID card reads as follows. Zachary T. Wester is a duly commissioned deputy sheriff in Jackson County, Florida, with full power to bear arms and arrest persons violating the law. Now, before receiving this incredible power, he swore the following oath, and it's on the other side of that exhibit. I do solemnly swear that I will support, protect, and defend the Constitution and the government of the United States and of the state of Florida, and that I will well and faithfully perform the duties of Deputy Sheriff of Jackson County, of which I'm about to enter, so help me God. Ladies and gentlemen, this is a case about the abuse of that incredible power. As the judge told you a moment ago, the defendant is charged with crimes of racketeering, official misconduct, perjury, fabricating evidence, possession of controlled substances, possession of drug paraphernalia, and false imprisonment. The evidence in this case will demonstrate and show that the defendant used the power of his badge to commit over 60 crimes against 12 members of this community. You'll hear that the defendant, Zach Wester, grew up in a law enforcement family and is actually from this area. Now, he began his law enforcement career elsewhere in Liberty County as a sheriff's deputy in Liberty County. He worked there for a brief period of time and then came home to work here in Jackson County as a sheriff's deputy. Now, because he had already been a deputy elsewhere, he knew how to be a patrol deputy, but he really needed to learn, as you would expect, how to do things at this agency, at Jackson County. And you're going to hear that he was put on an accelerated training program. He was not just put on the road in a different uniform for Jackson County, but he did go through a 4-week training program right here in Jackson County to learn how this agency, this sheriff's office, did things and how that may be different from Liberty County, but to make sure that he knew how to do it as a deputy here. Now, he worked, as I said, for 4 weeks under someone's direct supervision, someone called a field training officer. You may hear it abbreviated throughout the case as an FTO, but that's what that is, a field training officer. He worked under that person's direct supervision for that time, doing the kinds of things like you would expect. You're gonna hear that. That field training officer is gonna testify here shortly, and he's gonna tell you what all that entailed. But it's more or less what you would expect, how to handle yourself, dealing with the public, how radio and dispatch system worked at this agency, how to handle and collect evidence, where to place things, how to document things properly, all those kinds of things. You will hear that the defendant proved himself to be very competent. In fact, the FTO, field training officer, is going to tell you that Zach Wester was one of the best trainees he ever had. He never had to tell him anything twice. He proved himself to be more than competent and knew how to follow the policies properly of this agency. You'll hear that the sheriff's office has different divisions. They have a narcotics division, they have a command staff, an internal affairs division, and then they have what's called a patrol division. And some of you may know, but there will be testimony, and it'll tell you just in case, that a patrol deputy is assigned to a particular area of the county, and they literally patrol that area. They have those patrol vehicles that are marked, they're in uniform, and this is actually where most citizens in the public come into contact with a member of law enforcement. It's actually a patrol deputy. It could be anything from someone who makes a complaint and that person's the first responder. It could be a traffic accident. It could be you getting pulled over for a ticket. And that is how the defendant came into contact with each one of the victims in this case. Each one of them was pulled over by him during a traffic stop. One of the areas that you're going to hear a little bit about for that training is the use of body cameras. You'll also hear them referred to as body-worn cameras, but they're body cameras. And you'll hear testimony explaining what a body camera is, and it is what it sounds like, but it's basically a black camera that's affixed to the front of a deputy's uniform. And the idea is that it would allow whoever can watch a video downloaded from that camera to have the observation that the patrol deputy would have. There are many benefits to it, including the use of this very court system, and you will get to see many body cameras in this case. But the idea is that we can all see, as best we can, what really happened. Now, in February of 2018, a lady named Teresa Odom was driving home from seeing a family member at the hospital. She was pulled over by the defendant, Mr. Wester. Now, her truck at that time was pretty old and pretty beat up. You're going to get to see it on the video, and no one's ever going to contest that. Mrs. Odom will tell you that. And her brake lights were not working properly. So Deputy Wester pulled her over. And his camera turns on. He turns it on at the very beginning of that stop and makes contact with her, and you'll see that. Apparently there had been some weather the day before, a couple days before, and perhaps that had an effect on it, but either way, there were some issues with her brake lights. The defendant lets her know the reason for the stop. She says, yeah, I understand. And after that, the defendant asks her if he can search her car. She's going to tell you that she agreed. She didn't have anything to hide, so she said yes and got out of the car voluntarily. When she gets out of her car, there was already a second backup deputy behind her. So she got out, she walked back where that backup deputy was, and you'll see it, it's about a full car length's space, and she stayed back there with the only other deputy at that time who was on scene. And one thing that you'll notice when you watch Mrs. Odom's video at that point is so common to what these other victims will tell you in this case, and what the other videos will show you, is that while the defendant was searching her car, in other words, once she's out, he has complete access and complete control of that car. Only him. These backup deputies are out of view. They're literally back up. They're standby. And, of course, the occupants of the car are not still in there. They're removed. It's just him. And all we have is what his body camera video shows and what he would later put in his arrest reports when he arrested these people. Now, the defendant began the search of Ms. Odom's car at the driver's side door. And as he's getting ready to search, he's putting his search gloves on, these tactical black style search gloves, similar to ones that you guys have probably seen, but you will see them in the video, and they are evidence in this case. Now, as he's putting these gloves on, you can see on the video that he has his left hand clasped shut like this as he's putting them on. And you will see right here in this corner, you'll see a small white object in his hand, right by where his hands are clasped, as he's putting the gloves on. You'll see his hand drop down out of view towards the floorboard of Miss Odom's car. Now, you can't see where his hand is. As I said, it drops out of view at that point. And as I said earlier, the body cameras, the idea is that we can see as best we can what a deputy sees. And it's going to be up to you, the trier of fact in this case, to decide when things are out of view if that's intentional or if that's just the way it works, if it's accidental. But the video for Mrs. Odom's search will show basically her seat cushion. You'll see a purse in front of it, and then you'll see a seat cushion, a real close-up view of it. You'll see the defendant's left hand partially come back into view and reach over into her purse, which was in that seat. And her purse had the things in it that purses have, you know, her personal effects, her hair brushes, things like that. What you will see him take out of that purse, you can't see where he takes it out because that's partially out of view. But what you'll see him then take out and bring into view of the body camera is a small white baggie of methamphetamine. He takes that baggie and bends down and takes a metal spoon off of the floorboard of Mrs. Odom's car, and he sets the baggie of methamphetamine in the spoon. You'll hear that one of the ways that methamphetamine can be used is that it can be placed in a spoon. In other words, poured out of the baggie, placed in a spoon, and then some kind of a heat source, like a lighter, is underneath it, and then it is melted and placed into a syringe to be injected into somebody's arm or body. That's one of the ways that it can be used. Well, Miss Odom is going to tell you that that was an old spoon, and you hear her say it on the video. Says that was an old spoon that she had been eating yogurt with and had left on the floor of her car. Now, that's not going to be the cleanest or the most organized thing, but that's just what Mrs. Odom is going to tell you. And you're going to get to see her car and see for yourself that it's, by some people's standards, not the most clean car. Let's just say it. That's what she's going to tell you, and that's what it's going to show. But you're also going to get to see, members of the jury, that spoon. It is an item of evidence. You're going to get to see it. And on the bottom of that spoon, there will not be any burn marks, any char marks, any discoloration. When the defendant took that baggie of meth in that spoon, he walked it around from her car and walked it in front of her. And she immediately and adamantly denied it. She says, "No, sir. That is a yogurt spoon, sir. And I don't know what that is." She's adamant in her denial. She even asked Mr. Wester if they can test that spoon for yogurt. She asked him if she can test that baggie for prints. Now, that's not what they do roadside. That's not what a patrol deputy does roadside, but she's asking that, and you'll see it. Despite her pleading, despite her denying that it was hers, the defendant he does arrest Mrs. Odom, and he takes her to jail. The defendant makes a choice when writing a report for this and does not include that she requested that the item be tested for prints or that she even asked that it be tested for yogurt. Now, on the way to jail, the defendant drives her there, and you're going to get to hear from that video the defendant say something right from his own mouth on that video. He says, "I tell people this a lot," says this to Ms. Odom. "You got to be careful who you have around. And unfortunately, a lot of people you think you can trust, you can't." And just like that, Ms. Odom and the other victims that you'll hear from in this case will tell you that they were powerless and they were taken to jail for crimes they didn't commit, for allegedly having methamphetamine in their car that they say wasn't there until after the defendant was in their car and searched their car. In several of these stops, the defendant has what we're calling a partial body camera video. So it's different than Mrs. Odom's video that I just told you about, where it shows a stop from the beginning, the first encounter with that person, to the very end of that stop. Most of the videos in this case are actually partial videos. And by that, let me explain what you will see when I'm referring to them as partial videos. All we have from the defendant, from his body camera, are short clips. Some end before a search actually happens. You'll see some where he stops his car, he makes contact with the victim who's driving the car, explains the reason for the stop. He goes back to his patrol car, and then the video abruptly ends. However, that's not when his contact with the victim ends. You're going to hear from those people what happened after that video was off, after that camera was off. That he searched their car, and he allegedly found methamphetamine in it, which they denied was theirs. But it's off camera. There's no video of it. And all we have is what the defendant puts in his report to document it. Other times, it's the opposite. We have portions which begin immediately after a search has allegedly discovered or returned methamphetamine or a syringe or a straw or some item of paraphernalia with the methamphetamine. But we don't have, for no apparent reason, we have nothing before that. There's no video evidence before that to show him finding this methamphetamine or the paraphernalia. Now, we all know that there's mistakes in technology. That's the world we live in. Anybody that's got a computer or a phone, we all know it. And the Jackson County Sheriff's Office, their policy on body cameras actually contemplates this and addresses it, that there can be technological problems. There can be reasons why a body camera malfunctions, sure. And you're gonna get to see that in the policy. The policy is that those instances are supposed to be documented whenever they're discovered. A deputy is supposed to place in a report whether or not a camera was working entirely or not working, or only captured part of an event. And if known, there's supposed to be some kind of an explanation why. You will see these reports that the defendant authored in these cases for these victims, and not once does he report in there and explain why there are these partial videos. Now, fortunately, some of these stops, like Mrs. Odom's, had other backup deputies. And as I told you a moment ago, and as you're going to hear, the policy for patrol deputies was that they're supposed to press that button on that body camera, turn it on as soon as they're on scene, and they don't turn it off until they're done, even if they're backup. Well, fortunately, some of those deputies in the case actually were following policy, and that we have those cameras, and that's why we have extra videos that otherwise we would not have. And between the partial videos, a couple of complete videos, and then other backup deputies' videos, a pattern will develop, and you will get to see that pattern. It's up to you to decide what to do with it, and more on that later. But one thing that you will see often, and you will hear testimony about often, is that the defendant returns to his patrol car during the search. In other words, what I mean by that is the defendant begins a search of someone's car. Front seat, side seat, whatever, you're going to see that. But he searches an area for a little while. he returns to his patrol car. He then returns back to the car that he's been searching, sometimes the exact same area he's been searching. Only this time, he tells the victim that he's found methamphetamine and paraphernalia in their car after he's gone back to his patrol car. And he tells them that he's going to do something called a field test kit. A field test kit, for those who don't know, you'll hear testimony that it's not the same thing as sending it off to a lab to be tested, but it's the best that we can do at the scene to tell if something is really suspected methamphetamine or not. And you'll get to see pictures of one in this case, and you'll see the defendant use them in some of these videos. But it's a little plastic sleeve, not very big, smaller than a credit card. And the idea is that inside that sleeve, a portion of the suspected methamphetamine or whatever it is put in there, usually with a Q-tip, and you'll see the defendant do it. And then some little capsules are broken up, and if it turns a certain color, that indicates that it's methamphetamine. The defendant tells them that he's going to perform this test, does the test, and when these change colors, he takes these people to jail. When this happens, these victims oftentimes will have these same reactions, Ms. Odom: complete shock and immediate, adamant denial. You'll hear some of them, like Ms. Odom, ask for some kind of testing. I mean, right there in the moment, you'll see it on the video. They'll ask for if there's any chance or possibility to get DNA testing on the item, fingerprints. Some of them even ask to provide a drug test right there roadside. Now, that's not what patrol deputies do, but you're going to hear that on the video. And just like Ms. Odom, the defendant he makes a choice to not document those things in his reports, but you will see them on the videos. You're going to hear that during the investigation of this case, the state and the Florida Department of Law Enforcement did that to the extent we could. And you're going to hear testimony in a few days about that and whether or not that was able to really show much. It's up to you to decide during this case what value to place on it. But you will hear that not one of those victims' fingerprints were found on those baggies. There's a number of factors that go into that, and they're going to testify to that. But that's what you're going to hear ultimately. Not one. You'll also hear that because of the way that these items were handled by the defendant on video, that these items were ripe for what's called cross-contamination. And an FDLE DNA analyst is going to testify, and they're going to tell you exactly what cross-contamination is and how it can affect what value testing may have on something. Specifically, she has watched the Odom video, and she is going to tell you what kinds of factors may or may not affect cross-contamination. As I said a moment ago, each one of these victims is going to tell you that they were in disbelief and that they were shocked. At this point, the defendant offers a potential alternative explanation. He asks each one of them the same thing. Has there been anybody else riding around with you lately who could have left these things in your car? Maybe it wasn't you. Is there anybody else you can think of? You'll hear them ask these people this on the videos. And the ones with no videos or a partial video, they're going to tell you, yeah, he asked me that. They're going to tell you that because they were panicked, they were in this emotional state, scared, they racked their brains trying to think of anybody. Who's been in my car? Who's been in my car? They'll tell you that. And they just said some of the first names they could think of, people that had been in their car. The victims, after things got settled, a few days later, some time passes, they're starting to think about this incident more. And they're going to tell you that those really weren't reasonable names that they put out. Yes, those people had been in their car, but they will tell you that either those people hadn't been in the car in days, they weren't in the car by themselves, they didn't see that person with drugs when they were in the car, they didn't know that person to be a drug, to have methamphetamine that day, Or the defendant told these victims that it was somewhere in plain view, meaning it was like in a console, it was on a floorboard right under them. It was in an area that they could see, and they know it wasn't there. They just know it wasn't there. Once again, like the Odom video, you're going to get to hear something directly from the defendant's mouth on one of these videos. And he says, after one particular victim was offered up one of these situations, somebody who's been in the car that maybe, possibly, I don't know, he says, it's just not common for a meth user to leave their stuff behind. So after asking them and prompting them, well, could it have been somebody else? He follows up with, well, it's just not common. Goes ahead and arrests that victim and takes them to jail. Then there are instances with victims where there's just no video at all. There's a few with a complete video, several with partials, and there's some with just none at all. And once again, those reports don't mention, the ones authored by the defendant, don't mention that his body camera wasn't working, he realized at a later date. They don't say that. You're going to get to see those reports. They will be items of evidence for no apparent explanation. In these instances, all we have is what the defendant, when he has complete access and control of their car, chooses to report later. Ultimately, all these victims, regardless of whether it's a complete, a partial, or no video at all, these victims will tell you the same thing. They will tell you that the defendant didn't find anything until after he had been back to his patrol car or went to the front of his car, to the side of his car, and got some gloves. Either way, he's back there. And then returns to their car. They will tell you that they all immediately denied it, said it wasn't theirs, and they will tell you that these drugs, this paraphernalia, was not in their car until after that man, Zach Wester, had been in their car. Now, you'll hear that once they were arrested, they were charged, they entered the court system, and you will hear that a portion of them did plead. They were charged for what he arrested them for. And a few of them did plea, and they're going to tell you about that as it becomes relevant, as they testify. And just like we said in jury selection, everybody in the room is slightly different motivations, different life experiences. They're going to tell you from right over there, the ones that did choose to plea, why they pled. Some are going to tell you that they had family, they needed to get home. Some are going to tell you that they just wanted this nightmare over with, and the plea deal didn't seem that bad to them, they could handle it. And then some are going to tell you that they believed it was their word against a sheriff's deputy, and no one would ever believe them over a sheriff's deputy. They felt powerless. Now, shortly after the last victim in this case was arrested, a lieutenant at the Jackson County Sheriff's Office named Mike Hodges began what's called an internal affairs investigation into the defendant's use of his body cameras. Internal affairs is a different part of the sheriff's office which exists to do just that, make investigations when they're needed into members of the Jackson County Sheriff's Office. Lieutenant Hodges, Mike Hodges, began that investigation in mid-July of 2018. And by August 1st, he made the recommendation that the defendant be suspended pending the outcome of the investigation. And he also made a recommendation that this matter be referred to the Florida Department of Law Enforcement for an independent criminal investigation. You'll hear that while that investigation with the Florida Department of Law Enforcement, you may hear that referred to as FDLE in this case. When you hear FDLE, that means Florida Department of Law Enforcement. While that investigation was still in its beginning, Lieutenant Hodges and another deputy had taken possession of Mr. Wester's badge, his gun, his patrol car while he was temporarily suspended. And you will hear that they kept that patrol car secure and they searched it in September of 2018. And that search is video recorded. You're going to get to see it from beginning to end. You'll see that they began their search at the trunk of the vehicle, an area that many times on video you'll see the defendant return to during these searches with these victims. They opened up the trunk. The front center is a duffel bag, like a first aid style duffel bag. It's pulled out by Lieutenant Hodges, and underneath it, stuffed in the back of that trunk, is a brown paper bag. It's actually an evidence bag, crumpled up, stuffed in the back. It's unlabeled. It doesn't have a case name or a case number on it. It's not secured, meaning it's not taped up as evidence you'll hear should be. There's no markers or identifiers on it at all to indicate what case this could be related to. What criminal case? You'll hear that there's also a policy of the Sheriff's Office regarding recovered property or abandoned property. If a deputy just finds something, the policy is specifically you're supposed to treat it as evidence. There's none of those markers on this bag. You'll see that bag opened up on video by Lieutenant Hodges. And inside the contents of that bag are a couple of boxes. One's like a little scope box, one's a little watch box. And inside there, you will see over 10 items of methamphetamine in baggies and in containers. You'll find 5 items of marijuana and pill bottles or residue in the bottom of that watch case. You'll see a syringe. You'll see a pipe. You'll see 2 plastic knives. You'll see rolling papers. You'll see over 30 small plastic baggies, empty, the same type, along with those 10 that had meth in them, the same type that the defendant before this had claimed to have found on the victims in this case. Not one of these items was labeled or documented the way evidence is supposed to be in the way that the defendant was trained to handle evidence. The evidence will show in this case that's because it was not evidence from a real criminal case. Now, the search continued from the back of the patrol car and progressed to the front passenger side. In there's like a caddy station. A little kind of pull-over caddy that goes over the seat that holds things like your wallet, extra handcuffs, just extra things for convenience. And at this point, the video stops. The deputy that was assisting Lieutenant Hodges was taking a video with his phone, and he's going to testify, and he's going to tell you that he looked down, and all of a sudden he realized that it had stopped. He will tell you that he immediately tells Lieutenant Hodges that it stopped. They get it back up. They immediately state on the record, on the recording, what's happened and how much time has passed. And they make it clear that no search or anything has happened while they've been getting it straight. And then they continue. In other words, they document what happened and explain it. They continue into that caddy station. And in that caddy station, they found one of the defendant's black search gloves, the same kind you see him put on in the Odom video and in many of these other videos. Inside that glove, you will see what they find. They find a field test kit inside the glove. Again, not marked as evidence, no number on it. It's not inside an envelope labeled. It's a plastic sleeve, but it's not empty. It's got methamphetamine already in it. The capsules are not in there. It's not broken. It hasn't been activated or used yet. It's just preloaded in there, and you're going to get to see that. Next to it inside that glove is a clear canister. It looks like one of those old film canisters. And in that canister, more methamphetamine. Unlabeled, unsecured, undocumented, not treated like legitimate evidence, like the defendant was trained and knew how, demonstrated that he knew how to handle and document evidence. And that's also because the evidence in this case will demonstrate that it wasn't real evidence. It was not evidence from something else. In fact, we will present evidence that the records of the Jackson County Sheriff's Office were searched to see if there was any record which existed to document the defendant seizing anything, making an arrest, performing a search with somebody else, finding some abandoned property and documenting it the way you're supposed to. No such record exists, and that's what you'll hear in this case. In sum, the evidence in this case will demonstrate that the defendant planted methamphetamine and paraphernalia in these victims' cars when he had complete access and complete control. He used this fabricated evidence to arrest them and take them to jail. He falsely documented these facts in reports that the sheriff's office relied on and the court system relies on. And once his patrol car was searched, it will be evident exactly how he committed these crimes. By keeping a supply of methamphetamine and paraphernalia in his patrol car and preloaded inside his search gloves for ready use, to use against the citizens, the victims in this community. That's all, Judge.
Counsel.
Thank you, Ryan. Good morning, everyone. Yeah, my name is Ryan Davis, and I am here representing Mr. Zachary Wester. And you've heard from the state and what they believe the evidence is going to show. But remember, what the government says and what I say during our opening statements is not evidence. Just like back when we were at jury selection and the judge told you what the charges were going to be in this case, and he asked you if you had to vote right now, you'd have to vote not guilty because you haven't heard any evidence. And that's the same right now, today, as we're standing here. You haven't heard any evidence. You've only heard the opening statement of the state. But you, the jury in this case, you have the most important job, and that job is to decide what the facts are. And just because someone is going to get on that witness stand and swear to tell the truth doesn't mean they are going to tell the truth. It's your job to consider who and what is credible in this case. And you will receive some instructions at the end of the trial on judging a witness's credibility, but that doesn't mean you can't use your common sense. Everybody has common sense. And what you want to look for is you want to listen and watch the witnesses as they testify. Think about why are they testifying? What motives do they have? What, if anything, do they have to gain? And what interest do they have in how this case is going to be resolved? And as the prosecutor said, this case is essentially 12 drug possession cases. 12. But as the testimony is going on during this case, over this week and probably in the next week, there's some other numbers that I want you to remember. One of those numbers is 7. That's how many of those 12 entered into some type of agreement to resolve their case without challenging it in court. The other 5 were dropped before they could ever make it into a courtroom. 33. That's the number of felony convictions and crimes of dishonesty you're going to hear about from these 12 individuals, spread out amongst them. Now, not all of them will have a felony conviction, but we expect the evidence to show that there's going to be at least 33 prior felony convictions and crimes of dishonesty. 11. That's the number of backup officers that were on these scenes. That were right there. You'll see in these videos, from me to Mr. Wester right now, I could be a backup officer watching him search these cars in broad daylight. You'll see it on video. The number 11 again. how many civil lawsuits have been filed where 11 of these 12 are seeking money. Would that motivate their testimony? And finally, 0. Before Mr. Wester was suspended, that's the number of complaints against him about these cases. 0. Now I'm just going to go through briefly some of these individuals you're going to hear from. You're going to hear from a Joshua Emanuel. And in that case, you'll see the FHP trooper was also on scene, standing 15, 20 yards behind, broad daylight, watching the whole thing. You're going to hear from a Reginald Williams. Substance was found in his lunchbox. He also entered a plea. Steve Van, you're going to hear from him. And you also see that Dylan Jackson of the Jackson County Sheriff's Office was on scene. Mr. Van consented to his car being searched and does tell Deputy Wester, and you'll hear on the video, that after he finds the methamphetamine, he'll say, yes, I did. I had a girl in the car with me earlier named Crystal. And I don't know if that's a joke or what, but crystal meth? You're going to hear from Trevor Day. And you'll also hear from Jeff Tarter of the Jackson County Sheriff's Office on that case, who was there while that was taking place. You're going to hear from a Richard Driggers. And also about that stop, you're going to hear from Chris Maloney. At the time was with the Jackson County Sheriff's Office, now with the Florida Highway Patrol, who was there on scene while that search was taking place. You'll hear from Joshua Clenny. You also hear from David Carlberg, who was on scene with that case. And with the Joshua Clenny case, you're only going to see a video from the backup officer. And I'm sure this is one of the videos that the state was referring to, where they don't know where Mr. Wester's video went, or what happened to it, or why wasn't he following policy. But when that Joshua Clenny video plays, pay attention. Because at the end of the video, you're going to see Mr. Wester say, well, let me turn this off, and pushes the power button on his body camera. Now, it wasn't Mr. Wester's responsibility to keep track of those once he turns them back into the sheriff's office. That's Mike Hodges. And you'll hear about that as well. You're also going to hear from a Benjamin Bowling. And with Benjamin Bowling's stop, you're going to have Billy Button of the Jackson County Sheriff's Office on scene. And then Miss Teresa Odom. You're going to hear from her. And I believe the state has done a very good job of describing the video and how it looks. But you need to see it all for yourself. And you decide what's credible with that. And the state talked about Miss Odom asking for things to be tested. Right there. And the state was correct. That's not what the deputies do on the side of the road. They don't test for fingerprints. They don't, they're not testing for DNA. They don't have those capabilities. They do have the little field test kits that gives them a presumptive on the drugs. But again, that's not even enough for a conviction in these courts. It has to be sent to the lab, to FDLE, to their lab, for their analysts to take a look at it. And that's what you do when you litigate a case. You challenge the evidence. Ms. Odom says, he planted it on me. I want all this testing done. But she enters a plea, I think it's approximately 30 days later. You're going to hear from Maria Turner. Mr. Wester pulled her over for an expired tag. Said he smelled marijuana. And as what happens when deputies pull people over, yes, they do start racking their mind. Well, maybe somebody else was in the car. Maybe somebody did leave it. But I submit to you, it's going to be rare for somebody to get pulled over. Oh, you got me. It was mine. Take me away. Or is it more logical for people? I don't know what you're talking about. You're going to hear from Derek Benefield. And we believe the testimony from him is going to show that he was very adamant that he knew who was in and out of his car, and that the people that were in and out of his car would not leave something in there. Except for the night before Mr. Wester stopped him. Mr. Benefield was too drunk to drive his own car. Somebody drove him home, and he doesn't have any idea who it was. You're going to see and hear about the stop of James Fears. They were pulled over. The tag was not coming back, which would be a red flag for a deputy. And you also see that Trevor Lee and Rolf Smith of the Jackson County Sheriff's Office were also present on the scene. And that Trevor Lee, who at the time was with the Jackson County Sheriff's Office, but is now with the Bay County Sheriff's Office, participated in that search. And Trevor Lee was actually the one that found the drugs during that search. And then finally, Kimberly Hazelwood. You also see that Dylan Jackson of the Jackson County Sheriff's Office was on scene. And Deputy Jackson has a canine with him. The canine goes around that car and alerts that there's drugs in that car. And that's why Deputy Wester, at the time, searched the car. The dog said, "I smell drugs in there." And Miss Hazelwood will say, "Oh, I don't know anything about that. Somebody that I know that uses meth was in my car yesterday. And yeah, I purchased that container that it was bought in, but I didn't put it there." Now I want to hit a little bit on body cameras. You're going to hear more and more about the body cameras during this case. And we believe the testimony is going to show that it's about 2016 when the Jackson County Sheriff's Office first got body-worn cameras for their deputies. But not everybody got one. And eventually in 2017, pretty much by then, everybody else was going to have video cameras or body-worn cameras. And it was the responsibility of the deputies to make sure that they were docked. But there was also somebody at the sheriff's office who was supposed to be doing checks of the videos, making sure these videos are being downloaded, making sure that if there were issues that needed to be preserved, that they were being preserved. And that was Mike Hodges with the sheriff's office. And we believe the testimony and the evidence is going to show that he's going to have no records of anything he did, of any checks, any downloads, any maintenance, nothing. You might remember, well, yeah, I would check on them, make sure they were working, but he wasn't going back and reviewing and looking like he was supposed to. Because that was their policy, but that policy wasn't being followed. And you heard the state during their opening talk about policy. And they're going to say Mr. Wester wasn't following policy. So therefore, you shouldn't trust what happened with him. Well, it cuts both ways. Let's talk about the search of the patrol car that Mr. Wester was using. You heard the state say that they believe the evidence is going to show around July, mid-July, late July, early August is when they recommend FDLE take over the investigation of this case. And you're going to hear from the case agent, Ms. Chase. She went and she gathered up all kinds of evidence. All these reports, everything from, the sheriff's office, from the state attorney's office, gathering everything she could about all these cases, looking into everything. Why didn't she, or why didn't FDLE search his car? They had taken over the investigation at that point. That car sat there for 4 to 5 weeks before it was searched. I believe the policy of the sheriff's office is going to show they have specific policies on how you store vehicles that are going to be used for evidence or searched for evidence. They have a specific area where that vehicle is supposed to be parked. That's not where his patrol car was parked. The keys are supposed to be put in an envelope, sealed, and put in the evidence locker. Well, you'll see on the video, Mike Hodges starts the video with the keys in his hand. First thing he does, hits the button, trunk comes open. But according to their policy, that should not have happened, because they should have had to take the tape off the trunk first, the evidence tape. Per their policy, doors, windows, trunks, tape to ensure that nobody accesses the vehicle. But it sat there in a place where it's not per policy to sit for 4 to 5 weeks. FDLE has already taken over the investigation, but yet Mike Hodges does the search. I want to talk a little bit more about different levels of proof when it relates to the law. The lowest level of proof that we have is what's called probable cause. Probable cause. Is it probable something happened? Did something maybe happen? As a patrol deputy, that's what you need to make an arrest or search a car. Probable cause. The next level we have is what's called a preponderance of the evidence. Tipping those scales that 1% in your favor, 51-49. You're at a store, you slip and fall because they've done something negligent, and you hire an attorney to sue them. You need to show by a preponderance of the evidence that they were at fault. Next level is clear and convincing evidence. Clear and convincing evidence. That'd be if there's a professional, let's say a doctor, who they feel is a harm. Maybe he's drinking before he's going into surgery or something. Well, they still have to prove by clear and convincing evidence that this doctor is a danger before they can revoke his license. And then finally, you have beyond a reasonable doubt. I have no reasonable doubt that this happened. And that's where we're at today. We're not at probable cause, like what Mr. Wester needed to pull these people over and search their vehicles. We're not at a preponderance. We're not at clear and convincing. We're beyond a reasonable doubt. That's what the state has to prove to you. But I also want you to remember, you're not here to just rubber stamp the government's case. You're here to test it, you're here to analyze it, and you're here to question it. Kind of a little example I thought of. Say you're getting ready to go take a road trip with your family. Maybe you're going to drive cross country, go see the Pacific Ocean. Well, most people, probably before they took a long trip like that, would take their car into a mechanic. Hey, you're going to take a long trip, can you check out my car? Well, you don't want the mechanic to go, looks good to me. No, you want the mechanic to get in there, check the tire pressures, check the oil, check the fluids, check the belts, look under the hood. What we don't want you to be is the mechanic that just glances over at this case. Don't just rubber stamp it. Inspect the case. Kick the tires of the case. Look under the hood. Again, you as the jury have the most important job, and that is to decide what the facts are and what really happened in this case. That's your job. And you'll do that by listening to the testimony, reviewing the evidence presented, and it's the state's burden to prove their case beyond a reasonable doubt. We want you to listen to how the state presents their case and the questions they ask their witnesses. They're trying to get responses from their witnesses that are going to aid their theory of what happened here. But also listen to the questions that are asked by the defense. And then you're going to weigh the credibility of that witness. Pay attention to their responses, their body language, their tone of voice. That's why our Constitution requires accusers to come in here and take this stand and not just submit written statements. Because you all have common sense. And we want you to use your common sense in judging the testimony from that witness stand. We want you to evaluate their testimony. We want you to look under that hood. We want you to kick those tires. And again, I've said this many times so far, but it's the government's job, the state's job, to prove their case to you beyond a reasonable doubt. We don't have to prove anything. We don't have to put anything on. But we do want you to hear from all the major players in this case. So that's why I can tell you right now, you will hear from Zachary Wester. He will talk to you about every single one of those stops and what he did. That's why we need you to wait until you hear all of the evidence before you start discussing it, before you start deciding. That's why the judge tells you, even on these breaks, you can't start talking before you hear it all. And I know that's hard, but our system of justice depends on you following those rules. But I submit to you that when you hear all of the testimony and you see all the evidence, you're going to find that the state has failed to meet their burden, and the state's going to give you no choice but to find Zachary Wester not guilty. Thank you.
All right, let's go ahead and do our first witness, and then we will take our mid-morning break. State, who would you like to call first?
Virgil Watson.
Virgil Watson. Mr. Clerk, I'm going to have you swear Mr. Watson in. If you'll keep him remain standing. Mr. State Attorney, do you want the podium moved?
Yes, sir.
You want to
I
help
can move
with
it to
it?
the
Thank you.
spot right here.
Yes, sir. Mr. Bailiff's going to help you with that.
Sir.
Good morning, Mr. Watson. Mr. Watson, will you raise your right hand for me, sir?
Do you solemnly swear or affirm that the evidence you're about to give will be the truth, the whole truth, and nothing but the truth?
I do.
Thank you, Mr. Watson. You can sit down. Mr. Watson, I want to talk to you really quickly before the state starts asking you questions. A couple things for me. Our jury is out here today, sir. So if you will make sure that, Mr. Watson, our jury's out here, sir.
Oh, okay.
Okay, yeah. So that's who you're speaking to today. Mr. Bailiff, if you'll raise your hand in the back for Mr. Watson. you got to speak loud enough to where he can hear you. That way the whole room can hear you, okay, sir? If you hear an objection, if you'll pause your testimony, let me hear what the objection is, and then I'll instruct you how to proceed, okay, sir?
Yes, sir.
All right, Mr. State Attorney?
Yes, sir. Thank you, Judge. Mr. Watson, same goes for me. I'll try to keep my voice up. If with that divider there, if you can't hear me, just ask me to speak up, okay? All right, thank you, sir. Would you state your name for the record?
Virgil Watson.
All right, and are you employed anymore?
No, sir, I'm retired.
Congratulations. Before you retired, where did you work?
I worked at Jackson County Sheriff's Office.
All right, what was your rank or your title there?
I was, when I retired, I was captain over investigations.
Okay. Now, you said you retired. Were you working there from 2016 to 2018, that period?
Yes, sir,
Okay. Do you know the defendant, Zachary Wester?
I do.
All right. Could you identify him here in the courtroom? Just say what color tie he's wearing and point to him, please.
Red tie.
Okay. Judge, I'd ask that the record reflect that Mr. Watson has identified the defendant as Mr. Wester.
The record will reflect this much.
Okay. Just, I'm not asking too much how, but just generally, how long have you known him? Did you know him, in other words, before 2016?
I've known of him, and I believe we actually met probably when his dad was running for sheriff.
That was going to be my follow-up question. Did you know his father?
I did.
Okay, and was his father also a member at that agency for a while?
He was for a while, yes.
At the Jackson County Sheriff's Office?
Yes, sir.
Okay, and was he a ranked staff? Specifically, was he beyond just a patrol deputy?
His father you talking about? Or?
Yes, sir.
Yes, sir. I believe he was the captain.
Okay, and was he in narcotics for a period of time?
He was.
In 2016, did the defendant come to work at the Jackson County Sheriff's Office?
He did.
Okay, and did he come from a prior law enforcement background?
Yes, sir. I believe he worked with Liberty County.
Okay. Now, when somebody is already a sheriff's deputy in another agency and comes to Jackson County, do they still have to go through some kind of training?
They do have of course, a field training program.
Yes, sir.
They have to go through. Now, if they're experienced, they will a lot of times go less than the full 16 weeks.
That was going to be my next question. So 16 weeks is with no experience, correct?
Right.
And then there's a lesser amount of time if they have prior experience,
Yeah.
correct?
Yes, sir. It's up to basically the field training officer to determine, if he's up to par with our policies and everything.
Judge, may I approach the witness?
Yes, sir.
Mr. Watson, I'm going to show you what's marked as State's Exhibit 1A. You could open up that folder, just take a moment and look at it. Let me know if you recognize, yes or no, what's in there marked as 1A.
Yes, sir. That's Deputy Wester's ID.
Okay? And deputies that come and work with your agency have provided those kinds of IDs, correct?
That is correct.
Okay. Judge, at this time, I would move Exhibit 1A into evidence and move to publish.
Any objection?
No objection.
Be admitted.
Judge, may I approach the
Yes, sir.
course technology vendor? If you could just give me a thumbs up when that exhibit's up on the screen.
Need some help getting there? Let's see what you got. Give it 1 second, load up counsel. Thank you. Counsel, I think you got it up there.
All right. Thank you, Mr. Mayor. I was just going to ask you to zoom in. Now, there's a screen in front of you, Mr. Watson. First, I'll ask you, are you able to see that on the screen in front of you?
I am.
Okay, Judge, if we could, I see it on the screen for the jurors, but if we could inquire if it needs to be larger or smaller, just so that Mrs. Bittner, if she needs to zoom in or not.
You can zoom in as you need to, counsel.
Okay. All right. This is the front of that card, 1A, correct?
Yes.
Watson, okay. Mrs. Bittner, if you could zoom, just scroll down so that we can see the back of Exhibit 1A. And we see that
Yes, sir.
oath there, correct? Could you read that into the record, Mr. Watson?
Yes. Says, I do solemnly swear that I will support, protect, and defend the Constitution and government of the United States and of the state of Florida. That I am duly qualified to hold office under the Constitution of the state, and that I will well and faithfully perform the duties of Deputy Sheriff of Jackson County, on which I am now about to enter. So help me God. And it's signed Zachary.
Okay. Thank you, Mr. Watson. Now, you had mentioned the field training officer and the field training program, correct?
That's correct.
Okay, the records that a deputy completes documenting that they've completed that kind of training program, are those ordinarily kept and collected by the Jackson County Sheriff's Office?
Yes, they are.
Okay, may I approach the witness?
Yes, sir.
I'm going to show you what's marked as 1B, it's the field training manual. I'll take 1A back. And Mr. Watson, yeah, if you could take that accordion folder. A lengthy document, but if you could just review the first couple of pages and yes or no, let me know if you recognize it first. You can take that rubber band off it if you need
Yeah.
to.
It appears to be Deputy Wester's FTO manual.
Okay. And he completed that training, correct?
Yes, sir.
And Judge, I would move at this time states 1B into evidence.
Is it B as in boy or D as in dog, counsel?
B as in boy.
B as in boy.
Yes, sir.
All right. Any objection?
No objection.
1B will be entered into evidence.
I was hold publishing until later, witness, Judge.
Okay.
You had mentioned, Mr. Watson, policies and procedures of this agency, meaning the Jackson County Sheriff's Office, correct?
Yes, sir.
Okay. Was there a policy and procedure with the Jackson County Sheriff's Office at that time on the use of body-worn cameras or body cameras?
There was, yes.
Was there likewise a policy on evidence collection and processing?
Yes, sir.
All right, I'd like to show you what's marked as 1C and 1D as in dog. If I can approach the witness.
Yes, sir.
Record, I'm going to take 1D back and hand that to the clerk.
Got a mess here.
All right, first I'll hand you 1C. You can open that up and let me know if you recognize that to be that policy. Specifically, the policy on body-worn cameras.
Yes, sir. This is actually the Jackson County Sheriff's Office policy on body-worn cameras.
Okay, I'd move 1C into evidence, Judge.
Any objection?
No objection.
1C is admitted.
Again, I'll publish that to another witness, Judge. I'm going to show you 1D as in dog. Oh, I'm sorry, Mr. Watson, could I take that back? Show Mr. Davis that, sure. All right, I'm handing you 1D as in dog, and again, first, if you can look at that, let me know, Mr. Watson, if you recognize 1D to be the Jackson County Sheriff's Office policy on evidence collection.
That is correct. This is the Jackson County Sheriff's Office policy on evidence collection.
Okay, I'd move 1D as in dog and evidence, Judge.
Any objection?
No objection.
Be admitted as D.
May I reapproach the witness?
Yes, sir.
Mr. Watson, can you hand me 1D back? I want to keep all these together. Master accordion folder for 1A through D. All right, that's all I have at this time, Judge.
Okay. Mr. Davis?
I got just a moment, Your Honor.
Yes, sir. Take your time, sir.
We don't have any questions for this witness.
Thank you, sir. Mr. Williams, may this witness be excused?
Yes, but I ask that he remain under subpoena.
All right. Mr. Watson, you are not excused from all of your testimony in this case. There may be a chance you will have to be recalled for any reason. Thus, I'm going to ask you not to discuss anything that you talked about in here, any of your testimony in here, or any of the questions you were asked in here to any third party when you leave this courtroom. Do you understand? You, sir, you're still subject to the oversight of this court at this point.
Yes.
All right. You are excused, subject to recall, Mr. Watson. All right. I think it's a good time for our morning break. It's 10:08. Let me talk to you, and I'm going to do a version of this every time, but the first time is critical that you understand what's about to happen. We talked at the jury selection about what scares a trial judge is not what happens a lot of times in the courtroom, it's what happens when you walk out the doors. And this is the first opportunity that you have to do that. I want to go ahead and remind you that you are not to talk with anyone, including your fellow jurors, about this case. Other than the bailiffs, everybody in the courthouse has been reminded to give you space. That's why you're wearing that name tag. That tells them to give you space. So if you see somebody in the hallway and they look like they're trying to avoid you, it could be because of COVID in this day and age, but it's probably also because you have that juror name badge on. So please don't take that as anybody trying to be offensive towards you. I've instructed them to give you space and to let you go about your affairs. Do not talk with each other about this case until the end of the case, and we're nowhere near the end of this case yet. So you can talk with each other, just not about the case. Don't look up anything. Don't do any research involving this case. Don't go turn your phone on and look at any news blogs about this case. Don't watch any television about this case. Don't call your uncle who is a lawyer and get their thoughts about this case. Do not do any research with respect to this case. Don't tweet, blog, or communicate with anybody about this case. What's going to happen is Mr. Gary is kind of your conduit between yourself and the court, and he's going to be your conduit for the next couple of weeks. It is 10:10 right now. He's going to lead you out of the courtroom. You are going to leave your notebooks in your chairs, and we will make sure they're secure over our break. He's going to lead you out of the courtroom, and you're going to be back in that jury room with Mr. Gary at 10:25. That's 15 minutes for a morning break, and we'll reconvene you with that court in that jury room at 10:25, and we will bring you back in. Mr. State Attorney, Mr. Williams, anything that you need from the court before we let them adjourn?
No, Judge.
Mr. Davis, anything from you before we let this jury adjourn for a morning recess?
No, Your Honor.
All right, we will be in recess until 10:25. Mr. Gary?
All rise.
Thank you, Mr. Gary. All right, we're going to come to rest real quick. We'll let them begin to disperse as they need to. We made some extra bathroom facilities available to them, especially on a rainy day when there may be some limitations on going outside. Mr. State Attorney, anything that we need to address before the court takes its morning recess?
No, Judge.
Mr. Davis, anything from you before we take our morning recess?
No, Your Honor.
Counsel, if you'll be back seated at 10:20, it's about 10 minutes to take your morning recess. One thing I would ask before we get to the next witness, and I know the state's going to do this, is go ahead and take down what was published the last time, and we will continue onward. If the state would be sat and the defense would be sat at about 10:20, that would give us a couple minutes to talk about any preliminary matters before we get to our next witness, okay? All right, thank you. We are adjourned for our morning recess.
Yeah. Yeah, you take that. Yeah, the other way.
Yes, that's fine.
Yeah. Good idea.
I'll tell you, apparently these mics